Welcome to the next instalment of the Anson's podcast, and today we're going to be talking about corporate insolvencies. So we're talking about insolvency proceedings such as administrations, liquidations and CVAs. Let's move on then from talking about individuals to talking about insolvency in a corporate setting. So do you want to explain to those who are watching what the difference is between the two and the insolvency process rather than the bankruptcy? So
on one level, the difference isn't not particularly stark. They're very similar. Ultimately, the test for insolvency is the same. Can that company pay its debts as they fall due? And then the other acid test, as it's known, are its liabilities greater than its assets. If a company is in a situation where it falls into either of those two categories, again, there might be a consideration for its directors, its shareholders, to make about putting their company into an insolvency process. And equally, if somebody owes you money and you're concerned about ever getting it back, there is a remedy to petition to have a compulsory process imposed upon that company, a compulsory insolvency process, which would then see the company placed into a forced insolvency situation. And we can come on to the different names and the different types of these processes in a second.
I was going to say that there's a slightly different level, isn't there, in this sense, where it's not bankrupt or insolvent or not bankrupt or insolvent. There's another process in between, isn't there? So do you want to talk through what the insolvency options are for an incorporated?
Well, first off, actually similar to an individual, there is the workaround. There is the doing deals with people that you owe money to, whether that is negotiating time to pay arrangements. You'll often hear that with HMRC, who often is one of the big creditors if monies are owed for VAT or tax. Can you work out a deal with HMRC to pay them out over a period of time? Often, again, that's going to be probably the first thing that you explore. If not, you will consider and take advice upon, and we'll come on to this in a second, the different types of insolvency. The main two routes that people will have heard of, there are others, when you're doing it on a voluntary basis, is a liquidation or an administration. Okay.
Do you want to explain the difference then between a liquidation and an administration?
And I think the clue is in the names of both of them a little bit. So a liquidation is a liquidator is appointed and by the court, and that liquidator, or by the creditors, sorry, because there is a voluntary route into it as well, but a liquidator is appointed and their job is to collect all the assets, sell them and distribute whatever they've got as a dividend effectively to the unsecured creditors of that company.
And what happens to the company at the end of that process?
That company is liquidated, effectively killed off. It will eventually be dissolved, but the company is no more. And we're not wanting to sound this like it's Monty Python and the dead parrot, but that the company ceases to be. It typically will, the process of liquidation will be concluded and the liquidator will apply a form to fill out to have that company dissolved from the register.
And the liquidation's a cessation of trading, isn't it?
That's it. It's a proper sort of hitting a brick wall in terms of that company's existence. Yeah, it's the end. Versus an administration, and again I say there's a bit of clue in the name that where some admin occurs. An administrator is appointed. That's the title of the person who's responsible, a person or people, or sometimes it's typically two, who are appointed to run the affairs of the company with a view to, in some form or another, rescuing that company or that business as some kind of going concern, with an outcome that is meant to be better for the unsecured creditors. Now, where we see lots of admins like that is with football clubs. And an administrator is appointed and run that football club for quite a period of time. It happened at Derby County recently, and the idea being that hopefully somebody will come along and buy that company, or it's able to realise assets so that it can leave the administration. So unlike the liquidation, where the business sort of and the company smashes into that brick wall and is no more, on an admin, you can leave administration. The company can leave administration in one piece if it's able to sort of sell things or release monies that are due to it, and actually continue to trade as if it was never put into that process in the first place. I have to say, the sort of football club type admin, where it goes into admin and then comes out the other side as a legal entity, is relatively rare these days. Often what will happen is that the assets of that company are sold by the administrator to a third party, who will typically buy that in another corporate vehicle, and either the company itself will then go into a liquidation process, but it's easier for the business to be rescued in a form via that type of admin. And I see those far more regularly than a company that goes into admin and then gets out of the other side in one piece. It often can be called, and sometimes they get a bad name, a pre-pack, whereby in effect, or at least the implication is that the directors of the company who get together to place the company into the administration try and do some kind of deal whereby they can, via another company, a fresh company if you like, purchase the assets and rise like a phoenix from the flame, and for that to happen almost on the day that the company is placed into the administration, And they sometimes creditors get very annoyed and upset when that happens, quite rightly, particularly if they feel that the deal that's reached by the administrator is not in the best interest of the creditors as a whole. I mean, ultimately, the administrator will need to answer to those creditors and justify the deal that he has struck with them.
And let's be clear, just because something goes into administration doesn't mean it's a pre-pack. It could be a case that the insolvency practitioner tries to run it, doesn't work, realise they can't get it to where they need to, and so then they can sell the assets off, either individually or they can set it as a group at that point. And that's perfectly legitimate. It's a way of trying to raise as much money as they can to get back to the creditors, isn't it?
Yeah, no, exactly that. And I think that sometimes people are very cynical, and this sort of pre-pack has got a bad name. Most of the time, most of the insolvency practitioners that we deal with, the sale like that will be a last resort. They're trying to get the best deal for the creditors as a whole, 100%.
And just so that anybody watching this understands what we're talking about, when you're pre-packing, you're leaving all the debts behind in the thing that is insolvent.
Yeah, Company One. So if Company One goes into the administration, and let's say it owes £1 million of debts, but it owns a warehouse and a fleet of vehicles, the directors of Company 2 will come along with Company 2, perhaps having raised some money or put some money into Company 2, and Company 2 will buy the assets but leave the liabilities in Company 1. So they'll buy that warehouse perhaps out and the fleet of vehicles and run a new business. Company 1, the debts remain within Company 1. However, the money that is raised by that sale should then be distributed amongst the creditors of Company 1. But Company 1 itself has not got a future. It eventually will be either dissolved straight from the administration or will be placed into a liquidation process.
Okay. And in terms, you've sort of made the analogy of rising like a phoenix, and there are certain people that will come to you and say, "Oh, they've phoenixed this," but phoenixing's quite specific, isn't it?
Go on, on this one, Jason. You're gonna need to tell me what you specifically mean here. Go on.
Okay, so a phoenix phenomenon on an insolvency actually doesn't just mean that Company 2 buys the assets and carries on trading with a new business. What you can't do, and what people have to be aware of, is you can't trade under a name that's similar. You can't use the goodwill of the company that's gone down.
You can expose yourself. Yes, you are banned. You are precluded from using the name. You've got to be very careful with that Company too. If it was called MDR Limited, that are my initials, in case anyone hasn't worked it out. Company 2 can't be called MDR Limited. It's got to be called something different.
And something materially different. So it can't even be MDR2 Limited.
No.
And there's a whole series of rules around when the companies are set up. So and the sting in the tail is if anybody's thinking of doing this, what happens is the directors become personally liable for the debts
of Company 1. Of MDR1's debts, you become personally liable for that. That's correct.
And so you lose the corporate veil, and it can be potentially ruinous from an individual's perspective. So it's always something to have a think about.
It's another one of these things that, if you're wanting to be involved in a company that's going to engage in a rescue process, to take legal advice to make sure that you don't fall, for the pitfalls that will make you subject to a Phoenix type application, typically by the insolvency practitioner to pursue you for phoenixing in effect.
Yeah, absolutely. So moving on, we've talked about administration.
Yep.
We've talked about liquidation.
Yep.
What other processes are available for a company?
There is they can do in the same way, by analogy. You see less and less of that these days, but they can also go into what's known as a CVA, which is the C standing there for company, and that's the equivalent of a sort of workout, a formal workout that's binding on the creditors of the company. I do not see that happening very often these days. They've become rarer, a little bit because the administrations and some forms of the liquidations are better, more effective tools. Well, within a liquidation, we talked about you pursuing a process whereby you then will come on to how you can put a company into liquidation. Within liquidation, there is often what's called a CVL, which is a creditors voluntary liquidation, and that, in effect, the directors of the company and its shareholders will put a proposal out to the creditors. A meeting will get called, and those creditors will vote on the appointment of a liquidator and placing the company into that process. You can have, somebody might have heard of what's called an MVL, which is a members voluntary liquidation, but actually that isn't relevant to what we're talking about today, because to do an MVL, you've got to be solvent. So that's used typically when people are trying to, in effect, end the life of a company, but it's not a situation where people are owed money. And the other types of insolvency process that might affect a company are a receivership, which is typically initiated by the company's secured creditors, the bank, who might have a debenture, which is a form of charge, almost like a corporate mortgage, and they will put the company into administrative receivership. It is very similar to an administration, but they can use their mortgage document because you're in breach of that because you haven't been paying your regular monthly instalments towards your loan, and they can sometimes freeze your account and, in effect, appoint a receiver over your assets.
And just for clarity, why would they appoint a receiver rather than an administrator?
Well, because they, in effect, straight away, it freezes their charge. They will have more control over the process of the receivership to collect in the assets, which is what they're entirely interested in. That might be property. That could be, sometimes people will charge their book debts, the people who owe their money, and they will have complete control over that process, the person that they have appointed, and their job will be to collect in those assets, primarily to pay back the debt of the receiver, rather than perhaps the more broad outlook of somebody who's in an administration. The final category, which again I've seen more recently, I hadn't seen in the early part of my career, but then have seen more recently, is an LPA receivership, whereby it's about property, and there's typically it's in relation to a commercial mortgage and a trust. A receiver, again, is appointed purely. Sometimes the person might not be insolvent themselves, but they haven't been paying what they owe in relation to the property, and that person will be appointed LPA receiver, Law of Property Act receiver, purely to recover that property for the benefit of the person to whom the money is owed.
Okay. And talking about the different parts of the process, we've talked about what they are. How would the company put itself into it?
Well, I think that interestingly, I mean, listen, if a company is faced with financial issues, starting to get the red letters from not paying their debts as they fall due, which is the test of insolvency, starting to get judgments against it, or indeed even before that, what we would say to our clients in those situations is, look, you need to go and get some insolvency advice. And indeed, if you do that, that is what a reasonably prudent director of a company would do. Once you are in financial difficulty as a director, you have got what's called fiduciary, which means a serious duty, not just as before to your fellow directors and the board and to the company itself and its shareholders, but once you are starting to have financial difficulties, your duty now extends to the creditors of that company. So if you're racking up a load of CCJs, you need to be very, very mindful as a director that just ploughing on and continuing to run this business that is losing money, your obligation, you potentially have got an obligation to act in the best interest. Not potentially, you have got an obligation to act in the best interests of those creditors. So once you are hitting those sorts of issues, you do need to speak to your lawyer. You do need to speak to your accountant, both of whom may suggest that you go and get some insolvency advice. And if you did get that advice, that's you're discharging the duty to those creditors by realising that the writing is on the wall and prudently going to obtain some advice from an insolvency practitioner. Now, that insolvency practitioner, again, if it's a good one, will give you the different options and lay it out for you, all of that suite of different types of insolvency processes, if that's the way forward that we've just outlined. And if so advised, you may well, if all of the directors agree, go down a CVL or an administration route. Both of them are open to you. The shareholders do have to be involved if it's the CVL, less so on the administration side. He will advise you what the best, or he or she will advise you what the best process for you to adopt is. And then you will then initiate that. It's typically involving a meeting, filing some documents with Companies House in certain circumstances, depending on the process with the courts. And there's some paperwork. There's often a cost, and sometimes personally, if the company hasn't got the money, there's a fee to be paid to that insolvency practitioner in relation to their initial advice. And then assuming that the advice is to enter one of the formal processes, the relevant paperwork gets filed, and then the running of the company slips out of the director's hands and moves typically under the responsibility of the insolvency practitioners who are appointed.
And just so that we touch on it, although it could be a discussion in itself.
Yes.
We've already talked about fiduciary duties being very serious, very important. What happens if the directors don't follow that and they do decide that they're going to trade this business and just let it keep losing money? What's the risk? What's the risk of not going and taking that advice and not following an insolvency process? You
run a company, and if you've got a business, you should run it via a company, because you have what you mentioned it earlier, the corporate veil. I mean, it's lovely lawyer's language, but in effect, what that means is you are not personally liable for the debts of your company. And it's fundamentally sort of what stuff like the sort of industrial revolution and the growth of capitalism has been based on, is the limited liability concept. You can run a business, and yes, it might mean that you don't make as much money as you would want if that company fails, but at least your own shirt is not typically on the line. Now, if you run a company, and I think it has to be said, flagrantly run a company into the ground where it's continuing to trade, where it's absolutely obvious that the company should be entering one of these processes, there is an action that the insolvency practitioner can take against you for wrongful and indeed in certain circumstances fraudulent trading, and that's a personal liability. You can have to pay damages to the company effectively to its creditors for wrongfully trading that company when it was obvious and flagrant, and you made creditors' positions worse. If you were selling ice creams and you got 60-day terms on cash and carry, and each day you went out to sell your ice creams, but they weren't selling and they were melting. I guess you'd have to have a pretty rubbish refrigerator if they were melting. So you knew you were losing money. There has to come a point where you've got to stop going to that cash and carry because you're losing money every day, and it should be obvious to you that you're losing money every day. And if you continue sort of dunderheaded on, just keep making that creditor's position worse because you've got your 60-day terms, even though you know that you are losing money, rightly, the insolvency practitioner, whose job it is, part of his job, is to investigate the conduct of the directors, will likely say, hang on, it should have been obvious for you a long time before this company formally went into an insolvency process that you needed to have taken some advice as to what you needed to do and stop the things that are making the creditors' positions much worse.
And if they fail to do that, the directors can also be reported, can't they, to the DTS or BIS or whatever it's going to be called tomorrow.
This is what lawyers like us say, because it's been changed about 16 times. It's the artist formerly known as the DTI, and it was BIS at one point.
Yeah, that's right.
But I don't know what it's called at the moment. Is it called DTI again? Either way, at the end of the process, on every insolvency process, company insolvency process, the liquidator has to file a report, or the insolvency practitioner has to file a report, and often they can, particularly if something like this has occurred, state that recommendations about the conduct of the directors. And I have seen and have acted in relation to prosecutions by BIS, DTI, by the government, let's just call it that, to ban people from or suspend them from being a director for a period of time of any limited company.
And it can be quite significant, can't it? It could be 6 years, I think.
Yeah, often there's sort of plea bargains and whatever that can be done and undertakings given, but it can be costly to you as an individual, but also can stop you if you intend to be a director of a company. It can prevent you from doing that for quite a substantial period of time.
That can be really significant if you've got an entrepreneurial type who's got 5 or 6 other companies. It can stop you in all of them, can't it?
The one company falling over when you've traded it insolvently can have massive consequences, and quite rightly. Often these companies can be run recklessly with regard to the creditors' positions, and I think it's only right that in those circumstances the directors are made to account for it and there are consequences.
So we've talked about the processes. How do we put a company into liquidation, or administration, if that?
When we're a creditor.
When we're a creditor.
Somebody owes us money. Well, again, like I said, for individuals, in the strictest sense, you're not meant to use insolvency proceedings as a debt collection tactic. However, in circumstances where there's clearly an undisputed debt and you are a creditor, you've got a judgment against a company, you are able to place that company into a compulsory process. Typically, it will be a winding up petition, which leads to compulsory liquidation. Now, that can be based just purely on you've got your judgment, or there's a debt that the company's not said anything about, and you write to the directors and say this debt is undisputed. Clearly, you're not paying it, and that's evidence that's evidence that your company cannot pay its debts as they fall due, i.e. it's insolvent. Unless you pay us, we're going to start an insolvency process off. And also, again, similar to an individual, you can use a statutory demand document which gives them 21 days to pay, but is formally served upon them and often has the effect of a proper formal document, just as opposed to just another lawyer's letter. Often can have served by a bailiff, can often have a bit more of an impact to get their attention to to realise that they don't pay this debt that is set out in the demand, they unfortunately are going to be entered into an insolvency process, a compulsory winding up process against their will. They're the typical compulsory routes in. Clearly, we've touched upon secured creditors have got receivership options and administrative receivership options.
And these formal processes can have a bit more weight, can't they? Because even if you present and if you get paid, your other creditors can step in, can't they, as well?
They can substitute. They can take over the process. There's a bit of an administrative faff to doing that, but sure, yeah, because they're a collective remedy. Another creditor, because when you go through a compulsory winding up petition, when you go down that route, once that's issued, it will part of the process that you have to follow as that creditor that's owed the money is you have to advertise it, and that's advertising. It will appear online and on some of the credit searches that people monitor, the referencing agencies. And another creditor who's owed money may at that point say, hang on, I'm owed money too, and potentially have the option of taking over the petition, even in circumstances where the original petitioning creditor had been paid. One recent development, though, that we've been seeing, often that didn't happen until the advertisement had occurred. In the last 2 years, really, I started noticing it far more often that some of the credit referencing agencies, IT, is able to pick up as soon as a winding up petition has been issued against a company, almost immediately. And that can have the effect of a bank freezing the company's bank accounts and other creditors finding out far earlier than they used to do. Often it might take 2 months after the petition had been issued before it was advertised ahead of a 1 week before the hearing. Now that can happen virtually instantly. In some respects, it kind of blunts compulsory winding up petitions as a methodology of debt collection. Again, as we've said, they shouldn't really be used for debt collection purposes, because in the past, a creditor might say, well, look, you owe me this money, pay me or I'll advertise the petition. Clearly, and I'll advertise the petition, consequences of which your other creditors will find out and your bank will freeze your bank account. Now that the company's that's happening virtually instantly, to the point whereby the person who's issued the petition may not have had it back to serve it, but before the company has been approached by people who've picked up on the computer systems or on the internet, in effect, that the company's been placed into that process.
So it can be catastrophic from a very, very early point, can't it?
Once your bank account has been frozen, you can't. Most companies can't trade.
Yeah.
Most trading companies, that is the end, actually. And you can apply for interim injunctions to allow certain payments to be authorised, but the success rate of people once their bank account, people being able to sort of avoid being compulsory wound up in circumstances where the bank account has been frozen, are few and far between. I've been involved in a few where we have been able to successfully rescue the company and avoid the petition, but it's expensive and it's difficult.
And you're relying on largely personal assets at that point, aren't you, to be able to do it?
You would need or a group company or some other connected parties prepared to lend the money. Borrow the money. Is it? I always get that the wrong way through. Lend and borrow. If I'm giving you money,
lending.
I'm lending and you're borrowing.
Yeah.
You do owe me a tenner, by the way.
Do I? I won't ask what for.
I've made that up just for a joke for this podcast.
Thanks. Finally,
yes.
Then let's talk about. These are all going to be stressful positions for people.
Yeah.
They're going to be quite difficult. There might be a temptation to settle certain debts early, and there might be temptations, particularly if there are family ties or something like that, to try and get some of the assets out the way of the creditors, to do deals that might not exactly be in the best interest. They might be at a low value. It might be moving a piece of property out. It might be paying one debt over another one. What happens in those circumstances? Is that something that directors can do, or is that something
I think it's often something that we do see directors do, particularly in the compulsory situation where something's, they know it's going to happen and it's sort of against their will, is that they would try and transfer out an asset or try and pay the brother-in-law off who lent them 20 grand to pay last month's wage bill. so perhaps unsurprisingly, the law doesn't like that occurring, and because it's unfair. Why should the brother-in-law get paid his £20,000, whereas the other creditor down the road, the builders merchants, who's also owed £20,000, they're stuck with getting whatever the insolvency practitioner is able to recover. They get 5p in the pound. Brother-in-law gets £20,000. That's unfair, and the law recognises that, and will often call that what's known as a preferential payment, particularly here because it's made to a connected party, somebody you've got a connection to, and it's very broad definition of who a connected party is. If you do that, even within about 6 years of being insolvent, and you're insolvent at the time that's occurred, or in terms of you do owe people, you have got financial monies, financial pressures on your company, you're at risk of having that transaction set aside, and actually the insolvency practitioner saying to you and saying to your brother-in-law, I want that £20,000 back, that needs to be paid back. Transaction is set aside so that we can pay that money to the body of creditors as a whole. And all of the smart ALEC ways of selling something, buying something from brother-in-law, or paying something for all of those things potentially are vulnerable to an insolvency practitioner setting aside that transaction. Same goes for trying to sell some asset on the cheap. You allow brother-in-law to have one of the company vans for nothing, or at a song. Again, that's liable to have under what's called the antecedent transactions legislation, which is part of the Insolvency Act. That's likely to be vulnerable as potentially a preferential payment, stroke transfer of an asset, or a transaction at an undervalue. So, again, like with everything, I know that we're sort of like broken records here. That's where you need to get professional advice. You might have good reason why brother-in-law does need to be paid first. He might be your landlord, and if you don't pay him, he's going to close the gates. And that paying him, there's a good reason to pay him, as opposed to the builders merchants. In those circumstances, again, you need to obtain that advice, and the director who's got that professional advice will have, and indeed the brother-in-law will have the defence potentially when the insolvency practitioner starts to look at, and what they're duty bound to do, the events that lead up to the company going insolvent.
Okay. I think that rounds it all off. We've done a whistle-stop tour through insolvency and the various elements of it. All that's left to do, so thank you for watching, and join us next time.